exactly 50 years ago, President Lyndon Johnson signed the Civil Rights Act of 1964 into law. The passage of the law fulfilled a promise made by the late President John F. Kennedy, who made a speech 5 months before his assassination declaring his support for a bill that would outlaw racial discrimination in places of public accommodation. So this would be a public accommodations law, which is a law that applies to private businesses that serve the public. So hotels, restaurants, theaters, bowling alleys, docks, skating rinks, things like that. So this act was the first major accomplishment of Johnson's presidency, and it established him as a president who would finally throw the weight of the federal government behind the cause of civil rights. So today I'm going to talk a little bit about the history of the bill, but I'll also put it in a longer historical context in order to show just how revolutionary the bill was when it was passed. So we've got a problem, right? Our Constitution says nothing about civil rights. It speaks of privileges and immunities of citizenship, due process of law, equal protection of the laws. Those all come from the 14th Amendment, but these are really vague terms. Nowhere does the document actually mention civil rights or, of course, enumerate what they are. And yet, I think few Americans, or I hope few Americans, would argue that they simply don't exist or that they aren't somehow constitutionally protected. At least not Americans who are looking to get elected in 2014. But so what are civil rights? This is actually a really hard question. And where do they come from? So although our sense of civil rights really has its roots in British common law, since the founding, Americans have had personal rights, a sense of personal and political rights, though before, they're mainly protected by state governments. The Civil War and the passage of the 13th, 14th, and 15th Amendments brought the promise that individual rights would be enshrined in the Constitution and protected by the federal government. But as we'll see, it took nearly 100 years before this happened in a meaningful way for African Americans. So 1964 was not the first federal Civil Rights Act, though it's undoubtedly the most famous. In the preceding century, Congress passed 5 other Civil Rights Acts. So I'll talk a little bit about why that is and how they're different. The first in 1866, so right after the Civil War ended, was a precursor to the 14th Amendment. This law guaranteed to former slaves the right to contract, the right to work for wages, to sue in court, to own or lease property, all things that were prohibited by the former slave states. So certainly prohibited before the Civil War, but after the Civil War, the Black Codes were these really restrictive laws that prohibited those things, prohibited former slaves from doing those things. It also promised equal protection of the law, ensuring that states could not pass laws that levied unequal punishments on black and white offenders. So the Civil Rights Act of 1866, it essentially becomes the 14th Amendment, and why that happens is in some ways to make sure that the 1866 law would be deemed constitutional. It's part of the Constitution. It has to be constitutional, but also, they needed an act because a constitutional amendment always takes a little while. So a second act was passed in 1871 in response to the rise of the Ku Klux Klan. I'm sure you're all familiar with this terrorist organization that used violence and intimidation to deter black men from voting. The third Civil Rights Act, passed in 1875, was even more expansive, and this one looks a little bit more like we think of modern civil rights laws as looking. It was also a public accommodations law, applying to private businesses. It was enacted in response to the spread of racial segregation in the southern states. The law's champions were radical Republicans who understood that the promise of full social and political equality was under attack from white supremacist Democrats who sought to make African Americans into second-class citizens. So why, if the Civil Rights Act of 1964 essentially replicated many of the provisions of the Civil Rights Act of 1875, did Congress need a new law? Good question. So in short, the Supreme Court ruled that the 1875 law was unconstitutional. In the civil rights cases decided in 1883, the court took on cases brought by African Americans throughout the country, so this included northern states as well as southern states, who had been excluded from places of public accommodation because of their race. The plaintiffs sued under the Civil Rights Act, claiming that the 14th Amendment entitled them to equal use of places of public accommodation. The court disagreed. In the civil rights cases, the court stated that these instances of racial discrimination were private acts. This was important because the 14th Amendment explicitly applies to the states. And so it did not give Congress, the court says, the authority to regulate private behavior only public behavior. These were merely private wrongs, and so the federal government had no business telling these proprietors who they had to serve. You can see the beginnings of the court's endorsement of Jim Crow here, but these are not Jim Crow laws, right? These are private businesses that are discriminating. The decision asserted that Congress overstepped its authority by interfering with private action, but the Jim Crow laws that were passed in the decade following the decision were undoubtedly a form of state action. So you can see, in some ways, the civil rights cases presage Jim Crow, but not exactly, because they really are about private wrongs. Here, Jim Crow is all about public discrimination, right? Laws that demand racial segregation. Therefore, when states began passing legislation that required the separation of whites and blacks in places of public accommodation, it seemed to many that these were clear instances of states denying to African Americans the equal protection of the law. So despite the civil rights cases, despite that ruling, people like Homer Plessy thought that these laws would be held unconstitutional. It followed the logic of the civil rights cases that these were clearly public wrongs. And so it was surprising to many when the court ruled in the Plessy versus Ferguson case that the laws demanding racial segregation were, in fact, constitutional. The logic here was that as long as they applied equally to whites and blacks, these laws did not violate the 14th Amendment's Equal Protection Clause. And so Jim Crow found its constitutional basis firmly in the amendment, the 14th Amendment, that was passed to ensure racial equality in the wake of the Civil War. So the amendment that was supposed to be the Civil Rights Amendment becomes the amendment that essentially supports racial segregation. At the same time, the civil rights cases made it clear that the court interpreted our civil rights to come not from the federal government, but from the states. And there are several other cases that confirm this. This meant that though it was unconstitutional for Congress to pass a public accommodations law, the same was not necessarily true for the states. Indeed, in many northern states, I think in actually most northern states, legislatures passed their own state civil rights bills outlawing racial discrimination in places of public accommodation. So they took the federal bill and they made it into a state bill, and the Supreme Court said that that was fine. It's important to note that this did not necessarily mean that blacks were free from discrimination in these states, as many businesses discriminated nonetheless. So how this happened is that the protection of the law was technically on the side of African Americans, so they could use litigation to enforce these laws, but this was not always all that successful. So they would win because the law clearly said proprietors can't discriminate, but juries, oftentimes all-white juries, would give really small punitive awards to black plaintiffs, in some cases as little as $1. So as long as you could afford a lawyer, you could afford to discriminate. 82 years went by before Congress passed any further civil rights legislation. So the Civil Rights Act of 1875 dies essentially in 1883, and then we don't see anything. We see a lot of bills introduced, but they don't make it through Congress. So the next Civil Rights Act passed by Congress was signed by President Dwight Eisenhower in 1957, and it afforded very few new protections to African Americans. So it's a civil rights bill really in name and not necessarily in practice. As soon as the law was introduced, and it was much more expansive when it was introduced, Southern Dixiecrats, so Southern Democrats who were also segregationists, promised to block the bill's passage. This led to the famous Strom Thurmond filibuster, the 24-hour filibuster, which at that point was the longest in history, which is really pretty impressive if you think about it, 24 hours with no bathroom breaks. So, no one knows for sure. This is, doomed to be one of the 20th century's great mysteries. But, I've heard people who would know talk about how he probably had some device that may have helped him. He claimed it was just, his manly dedication that kept him from needing to end, but that doesn't seem to necessarily be true. So while Thurmond and his anti-civil rights colleagues failed in their quest to defeat the bill, they were able to weaken it enough, so forcing compromise with progressive Democrats and Republicans who supported it, that it didn't really create any new substantial civil rights protections. It did create the United States Commission on Civil Rights, which had the authority to investigate claims of discrimination, but did not have the capacity to do much more than collect information. So this law was very useful for people like me who love to read the records that the commission compiled, but they didn't really do anything about this evidence. So the law also had a clause regarding voting rights, which chipped away at the various ways that southern states sought to deprive African Americans of the franchise. But it didn't really attack the sort of poll tax clauses, the things that were really powerful in denying people the right to vote, the literacy test, things like this. This bill was shepherded through Congress by a Southerner who had voted against every other civil rights bill that came before him during his 2 decades in office. This man was, of course, Senate Majority Leader Lyndon Johnson. A fifth federal civil rights bill passed in 1960 likewise sought to expand voting protections to African Americans, but it also was basically toothless. It didn't attack poll taxes, it didn't attack literacy tests, any of these other legal devices meant to keep black men away from the polls. So what changed in the early 1960s that created the opportunity for Congress to pass a Civil Rights Act that had real teeth, one that would finally dismantle the core of Jim Crow? It was a combination of factors that put pressure on Congress to finally act. First and foremost, a mass social movement resisting racial segregation emerged in the South. In 1960, 4 black teenagers took part in the first sit-in at a restaurant in Greensboro, North Carolina. The refusal to give up their seats unless they were served was met with threats, jeers, and physical violence by whites, but their actions ignited a wave of similar demonstrations. Soon, across the nation, students protested racial segregation in restaurants with sit-ins of their own. The following year, white and black students rode south in the Freedom Rides in order to protest racial segregation on interstate buses, which was something that the Supreme Court had ruled unconstitutional almost 2 decades before, but it wasn't being enforced. So that's what the Freedom Riders were trying to do. They were trying to pull the weight of the federal government in to defend civil rights. But perhaps one of the most effective ways black Americans put pressure on the federal government was with the Birmingham demonstrations in 1963. This is where you can really hear my Minnesota accent when I say Birmingham. Forgive me. The protests had the violent response from Bull Connor and the Birmingham police were broadcast on national news programs, bringing the atrocities committed against nonviolent civil rights protesters into the homes of white Americans. Polling from the summer of 1964 shows that the Birmingham demonstrations brought a sense of urgency to the issue of civil rights reform. This was actually really effective for civil rights protesters, whereas only 4% of Americans thought of civil rights reform as the most pressing national issue before the protests, so early in 1964. Afterward, more than half did. So can't underestimate how important this televised violence really was. The assassination of President Kennedy was another major turning point in the fate of the Civil Rights Bill. Though Kennedy had expressed support, it had been stalled in Congress until Lyndon Johnson became president. And Kennedy didn't do much, really, to try to negotiate the Civil Rights Bill. He was worried that his other legislation would get caught up, would be held hostage, essentially, by segregationists. In his first presidential address to the American people, Johnson put forth a call to Congress to act as quickly as possible, stating, quote, "No memorial oration or eulogy could more eloquently honor President Kennedy's memory than the earliest possible passage of the Civil Rights Bill for which he fought so long. We have talked long enough in this country about equal rights. We have talked for 100 years or more. It is now time to write the next chapter and to write it in the books of law." The new Civil Rights Bill would fulfill the true spirit of the 2 that came before it, in that decade. Instead of allowing Southern filibusters to weaken the bill, Johnson, along with a coalition of religious leaders, moderates, and liberals, fought to avoid any compromise at all with Southern segregationists. It took almost 6 months of wheeling and dealing in the Senate to outlast a filibuster and muster the votes necessary to pass a strong civil rights bill. But on June 17, 1964, the Senate voted in favor of the law. A few weeks later, it passed the House, and Johnson signed the Civil Rights Act into law on July 2nd. With its passage, racial segregation in private businesses was once again illegal, as it had been briefly in the 1870s. But the Civil Rights Act was far more than a public accommodations law. It also prohibited racial discrimination in hiring. This is something very new, an objective that was key to civil rights activists who sought economic rights, along with political and social rights. Before the Act's passage, it was perfectly constitutional for a business to advertise in the want ads that Negroes need not apply, just as ads in the 19th century discouraged Irish from applying. The law also outlawed municipal facilities, things like public swimming pools, from discriminating on the basis of race, and it increased the ability of the Justice Department to pursue school desegregation suits against districts that refused to comply with the 1954 Brown decision. An important but often overlooked part of the Act allowed the federal government to withhold federal funds from state and local governments that continued to discriminate on the basis of race in defiance of federal law. So part of the problem with the other civil rights laws is they weren't punitive, right? They didn't punish people who didn't follow the law. So at this time, federal funds accounted for actually a pretty small portion of the money that schools used to operate. But this was remedied the following year when Congress passed the Elementary and Secondary Education Act, which included a dramatic increase in federal funds for schools. So this actually compelled a lot of districts into desegregation because they wanted that money. The baby boomers had to go to school, right? They needed to build new buildings. So finally, the 1964 Act differed greatly from those that came before it in a way that extended its effects beyond race. Representative Howard Smith of Virginia added sex to the prohibition on discrimination in hiring in what was probably an attempt to derail the legislation. Afterward, he claimed he was really for women's rights, but he was certainly not for civil rights. So most historians agree that what he was trying to do was to make the bill seem ridiculous, right? It's like, oh, well, maybe you support civil rights, but nobody, women, where does this come from? In fact, Smith's proposal to include the prohibition on sex discrimination was greeted with laughter in the House. People thought this was pretty funny. But the language stayed, and the bill passed anyway, creating a new opportunity for women to combat discrimination on the basis of sex. The act also prohibited discrimination in hiring on the basis of national origin, which is something that had never been encoded in law before. So how did the 1964 Act survive scrutiny by the Supreme Court, even though it was basically similar to the 1875 law? The court didn't overturn the civil rights cases. It's never overturned the civil rights cases. But rather, the Warren Court found a way around it in the 1964 ruling, Heart of Atlanta Motel versus United States. Instead of relying on the 14th Amendment's Equal Protection Clause or due process clauses, these stalwarts of civil rights, the court declared that Congress had the authority to prohibit racial discrimination in places of public accommodation through the Interstate Commerce Clause. The constitutionality of the century's most important Civil Rights Act relied on Congress's right to regulate commercial activity. By tracing the business of hotels and restaurants to travelers and trade, the court declared that these places of public accommodation were involved in interstate business. And the Constitution clearly says that Congress has the right to regulate interstate business. It's odd to consider the foundation of our modern understanding of civil rights might be found in the Commerce Clause, but it was through this bit of legal maneuvering that the Supreme Court stepped around the civil rights cases of the 19th century. In short, the most revolutionary aspect of the Civil Rights Act of 1964 was how it made civil rights protections a responsibility of the federal government, so moving it from the states to the federal government. After the civil rights cases, the Supreme Court essentially made civil rights a state's responsibility, which allowed Jim Crow laws to flourish in the South, even as other states made great gains toward legislating political and social equality. It was up to the states to decide what constituted civil rights, and so there was no guarantee that Black Americans would have equal access to opportunities in states where they could not vote. It took federal action to intervene and make real change. Thank you.
Freedom 101 is made possible by generous support from the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.